And now moving on to the Indian Copyright Act and how Indian Copyright Act has implemented two main provisions for digital rights management. The Copyright Act was amended in the year 2012 in order to make it compliant with the international internet treaties, that is the WIPO copyright and WIPO phonogram producers treaties. And even though India has still not ratified it, India is trying its level best to balance the interests of the copyright holders and the end users by having added Section 65A and 65B post the amendment of the Copyright Act. Under Section 65A, the anti-circumvention provisions along with the exceptions are stated. The three implications are of this section, three major implications of this section are: by limiting the application of anti-circumvention provision to cases related to purposeful infringement, there is a high bar for invoking actions under this provision. That means that one can limit the application of anti-circumvention provision in cases of purposeful or intentional infringement if the circumvention was not for the purpose explicitly prohibited by copyright law. The anti-circumvention will not apply. That is, if the copyright law has not been infringed and the circumvention was not carried on intentionally or purposefully or with a wrong illegal intention to tamper the rights of the copyright holder, the anti-circumvention provision shall not apply. The circumvention is also allowed with the help of third parties if certain procedural conditions or aspects are met. Furthermore, Section 65B of the Act says, if any person intentionally removes or alters any rights management information without informing the concerned authority, he or she shall be imprisoned for up to 2 years as well as fines. There have been similar punishments for persons who distribute, make copies, indulge in piracy, that is, indulge in internet piracy, or hack the right holders or other persons' information without his or her consent and communicate it to the public, and in a way tampering the rights management information, he or she would be penalized. The provision also particularly mentions the criminal remedies are in addition to the civil remedies provided under the Copyright Act for the owners. There was a recommendation by the Standing Committee after the amendment of the Copyright Act. As per the experience and the situations which occurred in the developed countries and the cases which took place in the developed countries, TPM's technological protection measures had stifled innovation. It was noticed that they also limited the access to public works, fair use rights, and overall hindered the privacy of the end users. The Standing Committee therefore suggested that the Indian judiciary, the Indian copyright law, or the lawmakers should evolve the law based on practical situations on a case-by-case basis. They should not implement all the stringent provisions for all the cases in common. On a case-by-case basis, they should implement, as India is a developing country, we need to promote innovation instead of stifling it. We need to make public works accessible to the public. We need to make new and novel content by means of fair use available to the public, and also take into interests the rights of the copyright holder as well as the end user. Committee also recommended minimal legislative interference in the proposed amendment to Section 65A, and rather that there be some sort of judicial analysis if and when required to create rules and guidelines based on current trends, the latest trends, and on a case-by-case basis. Because they want to facilitate access of the works done by the copyright holders to the public in a legitimate and secure manner to balance the interests of both the parties. Moving on to the comparison of three jurisdictions, the US, European Union, and our own country, India, which is a developing country. So here the main difference lies between the fact that US and EU have a well-framed copyright law which they have been practicing for over a decade now, for over 2 decades in fact. DRM provisions in India are less extensive and, as we discussed, implemented on a case-by-case basis with least intervention of the judiciary in cases where it's not required when compared to DMCA and Information Security Directive of Europe, which are far more reformed. The DRM provisions in the United States and European Union have been in existence for a decade now, and so lay an effective platform for others also to learn and follow. The absence of terms like technological measure create a gap while interpreting the Indian law. So this is a drawback as to whether the provision relates to access control measures or copy control measures or both per se. So there is definitely a gap in the law, in the Indian law, when it comes to the terminology, which is more explicitly given in the Information Security Directive of Europe or Digital Millennium Copyright Act of America. It does not appropriately differentiate between effective technological measure and non-effective technological measure as well. I would conclude by saying that DRM is theoretically introduced to help copyright owners by protecting digital content from illegal copying or distribution. It is still very contentious to say that since DRM imposes restrictions, it might impose certain restrictions on legal users and might hinder innovation and free flow of information, especially for growing economy like India. On the other hand, on one hand, it is protecting the rights of the copyright owners by protecting their contents from getting illegally copied or their contents being infringed. It is still very contentious, it is still very disputed that even though these factors are very important, DRM is still stifling competition, is still stifling the use of public works, fair use, and it's still imposing many such commercial restrictions on the legal users which would otherwise be benefit for the larger good of the public, and especially for a growing economy like India. A comparative analysis of EU, US and Indian copyright regime shows that even though India has tried to implement the provisions of the international internet treaties to a certain extent, there are still many gaps in the case laws which make the interpretation of law very complicated. It does make the law complicated because there are certain technical terms which are not explicitly distinguished, which are not explicitly given in the legal text, in the provisions. So India needs to still work harder on the amendment of its Copyright Act, but at the same time it has a duty to maintain and balance the interests of both the end users and copyright producers. Thank you.